welcome back to uh, the subject of patent infringement and the requirement of patent search in the context of patent infringement. Now, in the last class we have seen the procedural aspect of patent infringement, and we have seen that who can be parties to a patent infringement litigation and what are the issues of evidence law that needs to be taken into consideration while pursuing a case of patent infringement. Here actually we will be getting into the substantive aspect of patent infringement in this class. As we have seen in the last class, the roadmap what we have learned that the suits relating to infringement, it can be classified into three categories: infringement suit, declaratory suit and suit against groundless threat. And we were trying to understand infringement suit. But here we will understand that a patent can be infringed in two ways. It can be infringed, which is called directly and which is called literal patent infringement, and it can also be infringed in a non-literal manner, which is indirect patent infringement. Not in the sense of indirect patent infringement also includes actually secondary patent infringement. Here we are not talking about secondary patent infringement, rather than we are talking about patent infringement which takes place where the infringer has not taken the specific elements which have been mentioned in a patent claim or specification, but under certain such situation he or she may be liable. Now, first let us try to understand that what is literal patent infringement and which is very simple and straightforward. Now, the principal rule actually a literal patent infringement happens when the infringing product contains each and every limitations captured in at least one claim, that is technically and which is technically called the patent is the infringing product is reading on the infringing on the claim. Now, here what has happened? What happens here is this: the question is this, that there are, as we know, that a patent specification contains several claims and each claim contains several limitations. See, if here the issue is very clear that the infringing product or the infringing process or the accused what you call device must infringe at least fully one claim. Now, let me substantiate it, let me what you call give you an example. Suppose there is a patent, and if that patent actually it has captures three different limitations, and these limitations are, say for example, M, N and P. Any product which contains actually M, N and P would be an infringing product. Suppose actually here the question is this, that the claim number 1 contains M and P and claim number 10 contains N and if the infringing product is actually what you call covering M, N and P together, in that case it would not be a patent infringement in the non-literal sense, but it can also be an infringement under the doctrine of what you call non-obviousness, and therefore, the defendant in such a suit would claim that the patent is invalid because it is hit by the provision of non-obviousness. Now, suppose if let us talk about three different product. One product is consisting of M and P, clearly it violates the patent literally. Another product, it contains some additional feature, say for example, it contains M and P and in addition to that it also contains X. in that case it is also an infringement of patent, because MNP, all the limitations of the claim are present in this product. Similarly, if someone adds 2 more features to the existing what you call invention, say for example, in addition to MNP, the producer has added S and T, still since M and P are common and in M and P are all the limitations of the claim number 1, therefore, it would constitute literal infringement. Now, in this regard, let us try to understand that what is the scope, and we will be trying to understand it with the help of examples, and those examples are obviously case laws. Now, here there is a case law which is coming, and I think this would help you to better understand the concept of literal infringement. In Laramie Corporation versus Amron, what the issue was regarding a water toy gun. What was the plaintiff actually, the plaintiff, which was basically they filed a declaratory suit, and which we will come to know little later. The plaintiff were actually sought a declaration that actually it used to produce a toy gun which could be filled with water, and these are known as super sockets. And the plaintiff, they discovered that there is a patent which belongs to the defendant, and therefore, the patent the plaintiff, that is actually Laramie Corporation, they filed a suit for a declaration to the effect that actually their product does not infringe the patent of the defendant. When this suit, what has happened? The defendant here, there are 2 defendants here, one is Allen Amron, and then another company, Talk to Me Products Incorporated. They have actually filed a counter claim saying that the super soaker guns, they infringe they have an US patent, and this US patent actually you can see this in the screen, and this patent was infringed by the product of the plaintiff, and this was actually a counter claim by the defendant. Now, let us examine what are the 2 things, and this is actually what you see in the screen is the drawing and claim number 1 of the US patent. And if you read it, you will find that it is saying that a toy comprising of an elongated housing having a chamber therein for a liquid, a pump including a piston having an exposed rod in a extending rewardly offset toy facilitating manual operation for building up an appreciable amount of pressure in the said chamber for ejecting a stream of liquid therefrom an appreciable distance substantially forwardly offset toy and means for controlling the ejection. So, this is actually a simple toy gun where one can actually draw water, and the liquid containing chamber, to be very precise, the reservoir is located inside the gun. Now, the question that comes up before this, the defendant patented gun, it actually, as you see that the liquid actually is stored in a reservoir which is a part of the gun. Now, look at the product of the plaintiff, and as we know that as we have learned that the plaintiff has filed the declaratory suit. The Super Soaker 20 had an external water reservoir, and that was detachable. So, here what has happened, the patented product had a reservoir which is located inside the gun, and whereas in the other product, the Super Soaker product, it was something which was located outside the gun, and it was actually something which could be attached and which could be which could be actually detached when the circumstances needed so. Now, the court held that the Super Soaker 20 gun did not literally infringe patent claim number 1. This is very clear. See, the striking difference between these two is this, that in the patented product it was located inside the gun, and when it comes to the Super Soaker gun, which is also a toy gun, it is located outside the outside the gun, and therefore, the court held that it is not a case of literal infringement. Now, the question is this, that we will try to find out later, that whether this can also constitute something which is called the non-literal infringement. Now, let us come to the understanding of non-literal infringement. The understanding of non-literal infringement in India we will discuss it later in the coming class, but let us try to understand that how this non-literal, the concept of non-literal infringement came into existence, and how it performs a very important function in the policy of patent law. Now, to be very precise, here what has happened, what we have learned, if the patent claim should be given their plain and the simple dictionary meaning, and if the accused device is falling within that dictionary and plain meaning, it would be a case of literal infringement. But here you can see some of the most important paragraph in the doctrine of equivalence, and I am quoting a 1950 case, and this case was decided prior to the enactment of the 1952 US Patent Act. So, the issue what you can see in this screen, that actually the court has captured that actually a person who is trying to imitate someone, he actually being an intelligent copier, he would not be imitating, he would not be copying verbatim. Rather than what he will do, he will try to add here and there certain cosmetic changes, so that to someone who is purchasing that product or who is using the product can think that it is altogether a different product. Now, these are the parameters which you can see in the screen, which tells us, suppose here actually the court first says, in this case this is a decision coming from the Supreme Court of the United States, which says that outright and forthright duplication is dull and very rare type of infringement. So, here as I have said, that a person who is intelligent enough, he would not copy verbatim, rather than he would make changes here and there, he would be making certain cosmetic variations and amendment, so that it appears to the others to be a product coming from him and not to be an infringing product. In addition to that, one who seeks to pirate an invention, like one who seeks to pirate a copyrighted book or play, may be expected to introduce minor variations to conceal and shelter the piracy. Just now I have mentioned this. This is the wording used by the Supreme Court of the United States. Then comes the logic. Permitting, as I have, let us understand this paragraph first, and then we will try to understand what implication it does have. Permitting imitation of a patented invention which does not copy every literal detail would convert the protection of patent grant into a hollow, useless thing. Such a limitation would leave room for indeed encourage the unscrupulous copyist to make unimportant and insubstantial changes and substitutions in the patent, which though adding nothing would be enough to take the copied matter outside the claim and hence outside the reach of law. Let us go back to the first class, where we have understood the logic, the justification for patent. It ensures that patent law ensures that the public domain is actually safeguarded. At the same time, it ensures that a person who has come out with an invention which is genuinely new, he should be getting a reward for the invention, and this reward is given in the form of a monopoly alike structure, and that monopoly alike structure is actually a protection for a limited period of 20 years. Now, this is also, we have seen the threefold incentive of patent. incentive to create, incentive to invest, incentive to disclose. Now, here if a person find if the patent holder, if he finds that a person who has made what cosmetic alteration and addition here and there, and by that way he is actually trying to escape his liability for patent infringement, no one would actually would dare to invest in things which are actually very valuable in nature. And therefore, doctrine of equivalence actually goes beyond the literal meaning of the patent. It also captures things which in a reasonable manner should be a part of the patent claim. And from there, the non-literal patent infringement doctrine, which is basically which is known as doctrine of equivalence in the United States, has come into existence. Now, let me further go into the in-depth understanding of this doctrine of equivalence. And again, this is actually this quotation comes from Gravatt-Rank, the case law which I have just now referred, and this what does it say? That the doctrine contemplates that a patentee can proceed against the producer of an accused device if the device, there are three cardinal principles which are laid down. What are the three cardinal principles? That the accused device performs substantially the same function, what you call a kind of what you call similarity, equivalence of functionality. And then the second point, it in substantially the same way, the manner of functioning, the way the claim, what you call the infringing or the accused device is functioning, so it must function in the same way, in the manner of functioning, and then the ultimately the end result of both the infringing product and as well as the infringed product are one and the same. If these three are complied with, no matter what the language says, what is the interpretation of this, the court will find that the accused product has infringed patent. But at the outset, I must inform you that it is very difficult to, it is one of the most complex doctrine of patent law, and at times it becomes very difficult to apply this doctrine. But let us try to understand it further. For example, take the same example that there is a patent claim with regard to a device comprising of M, N and P. This claim would be say for example, what happens in order to avoid literal infringement, a person comes out with a product which consists of M, N and some other feature which is X. Now, as we have seen that the limitation of literal patent infringement is this, that all the claim limitation must be present in the infringing device and it must be related to a single claim. Now, here in order to avoid that, as we have seen that the imitator, the plagiarist, what he did, he has come out with a additional feature which he says X. Now, Mn he has taken from the claim, but X he has not taken from the claim in order to ensure that he does not land up in literal patent infringement. Now, here if the patent owner can prove that X is nothing but an equivalent of P, he would be able to succeed in establishing a non-literal patent infringement. Now, here the most, as I was mentioning, it is one of the most complex doctrine. Why? Because what constitutes equivalency must be determined against the context of the patent. Number one, the context of the patent, the prior art and the particular circumstances of the case. Equivalence in patent law is not this is the most important issue. There is no hard and fast rule. At the same time, it is also not actually suspending in a vacuum. So, equivalence in patent law is not the prisoner of a formula. At the same time, it it is not an absolute to be considered in vacuum. So, there are guidelines, but there is no what you call there is no straightforward straitjacket one time formula to determine what is equivalent and what is not equivalent, and there are guidelines, and these guidelines have to be looked into in view of the prior art which was existing, the particular circumstances of the case, and as well as the context of the patent. Let us try to understand, because I was giving you quotations from this case law which is called Graver-Trunk versus Linde Air Linde Air Products Company. Here what is the subject matter? Let us try to understand the technological backdrop, and we will try to understand the legal backdrop later. Here the two products which were litigated, they were related to electric welding composition. We are using actually fluxes for electric welding, and one was patented and another was something which is actually used by the defendant against whom the suit for infringement was filed. Now, the patented one actually was known as Uni-on-Melt grade 20, and this claims a combination of alkaline, earth metal silicate and calcium fluoride. So, earth metal silicate plus calcium fluoride. However, what has happened, because it was talking about earth metal silicate, alkaline earth metal silicate, but it in fact used the two particular what you call elements which are there, two particular silicates. It actually contains silicate of, it used calcium and magnesium, and as we know that calcium and magnesium, these two are alkaline earth metal silicates. Now, the accused composition as you can see in this screen, the name of the accused composition was Lincoln Weld 660. In this actually accused composition, this used silicates of calcium and manganese. Look at in the earlier what was used, the patented product uses calcium and magnesium, but the accused composition uses calcium and manganese, and we know that manganese is not an alkaline earth metal. And this calcium and manganese replaces what we call silicates of calcium and magnesium. So, magnesium is replaced by manganese, and magnesium, as we know that it is actually a what we call alkaline element, a two alkaline earth metal, and whereas manganese is not alkaline. In all other respect, these two compositions were same. Not only that, the mechanical method in which these two compositions are employed, these two compositions employed were also same. So, therefore, the question is this, that whether it amounted to infringement of copyright before the Supreme Court of United States. And this is the seminal case where the court laid down this doctrine of equivalence. Obviously, the Supreme Court lays down the doctrine of equivalence in clear terms, and which has later also been followed by the Supreme Court of United States. Now, the issue before the court, what was the issue before the court? The issue, as I have mentioned, that whether the substitution of manganese, which is not an alkaline earth metal, for the magnesium, which is an alkaline earth metal, come under the doctrine of equivalence. So, here what the court says, it is difficult to conceive of a case more appropriate for application of the doctrine of equivalence. The disclosures of the prior art made clear that the manganese silicate was a useful ingredient in welding composition. Here, what was the prior art? The prior art shows that the manganese silicate was used as an useful ingredient in welding composition, and because of this, actually it is quite obvious to a positor quite obvious to a person having a kind of knowledge about the art in respect of which this invention was related, they would actually relate it to manganese, because manganese is something which was used as an welding, as an ingredient in welding composition, and therefore, the Supreme Court in this case held that it constituted non-literal infringement under the doctrine of equivalence. But there were dissenting opinions in these cases also, and we will be talking about those dissenting opinions at a later stage. Now, here one more important observation that comes from what we call the Warner-Jenkinson rule. Here, first of all, at the outset, before I get into the case, this case, in addition to laying down examples of the situation where there is actually a kind of range is mentioned how to deal with equivalence, it discusses, but at the same time it lays down a very important principle of law, which says that the equivalence should be measured not at the date of invention rather than on the date of infringement. What does it mean? Suppose if the patent was issued on 1st January 2010 and the infringement suit is filed on 1st January 2019, then the equivalence, the prior art, the relevance and all other issues must be measured as it stood on 1st January 2019, not as it was on 1st January 2010. So, in other words, what does it mean? This particular ratio developed by the American Supreme Court allows a person to capture the technologies which has arisen in between 1st January 2010 and 1st January 2019, and this is actually clearly an indication that the patent holder can also capture the after arising technologies. With this observation, let us go into the understanding. This is another example which illustrates the doctrine of equivalence. And here, to be very precise, the trial court rules that there is a equivalence. The en banc Federal Circuit Court of Appeal is actually also holds the same thing, but when it comes to Supreme Court reverses and remanded back the case to look at it from the ratio which they have laid down in this case. Now, here, to be very precise, the question, the principal argument before the court was this, that the 1950 doctrine of equivalence is not applicable, because the statutorily it does not talk about equivalence. The 1952 Act does not talk about equivalence as such, and therefore, this cannot be, the doctrine of equivalence was no longer applicable in the US under the 1952 Act. We will come to that little later. Now, here there are two, the parties to this litigation, Warner-Jenkinson Company and Hilton Davis, they were manufacturers of dyes, and as we know that these dyes require a removal of impurities. Now, Hilton Davis held a US patent, as you can see the patent number there, which discloses an improved purification process involving ultrafiltration. So, here how to filter the dyes? There they have come out with a patented mechanism which actually improves the purification process of dyes, and which is basically employing the ultrafiltration technique. Now, let us go straight to the patent claim, the relevant patent claim, and as you can see that actually this is the relevant patent claim, and then we will find out what are the striking features in the claim. In a process for the purification of a dye, the improvement which comprises number 1, subjecting an aqueous solution to ultrafiltration and this is achieved through a membrane having a nominal pore diameter of 5 to 15 Armstrong. What is the range? 5 to 15. Under a hydraulic pressure of approximately 200 to 400 psig, and then it mentions, this is the most important part, and this became the subject matter of the contention, at a pH from approximately 6 to 9 to thereby cause separation of the said impurities from said dye. So, here there is a pH range, and what is this pH range? The pH range is 6 to 9. Now, why it is like this? The prosecution history it shows that when the inventors they applied for patent, they had to actually mention a pH range from 6 to 9 during the patent prosecution. Why? Because the phase was added in order to distinguish this invention from a previous patent, from a prior art that disclose ultrafiltration process operating at a pH level of 9 and above. So, above 9. So, here there was a prior art which disclosed that the pH value for this filtration method should be above 9, and here actually a new improvement comes out, which in addition to the diameter of the membrane, it meant in addition to the hydraulic in addition to the pressure also mentions the pH value, and this actually this is from 6 to 9 and the prior art is above 9. Now, look at what happens. See, the Warner Jenkinson, they developed actually this in 1986 they developed an ultrafiltration process that operated with membrane pore diameters of 5 to 15 Armstrong at a pressure of 200 to 500 psi and at a pH of 5. There is a specific pH. What is this pH? This pH is 5. So, the prior art before Hilton was above 9, Hilton contemplated 6 to 9, and here Warner Jenkinson is actually using a pH value of 5. So, when this product they started selling this product, they were not aware of this, and then when they came to know about this and when they did it in 1986, and then in 1981 Hilton Davis they became aware of this, they came to know about this, and they filed a patent infringement suit before the what you call before the trial court. Now, in what has happened, the trial court says that the trial court found that this was something which was coming within the doctrine of equivalence. And then, as I have mentioned, the federal court or circuit court of appeal, and as you know that acts as the national court of appeal in the United States, they also upheld this verdict. The Supreme Court actually remanded it back. What was the observation of the Supreme Court? The Supreme Court says that if Hilton can establish that the reason for amendment was not to limit this patent, then still this infringement on the ground of non-literal violation can also be entertained. But the prosecution, there is obviously there is a doubt that whether in fact Hilton mentioned that limit from 6 to 9 in order to limit the patent. If it is not to limit the patent, in that case actually the issue of non-literal infringement can be taken up, and the court remanded back the case for the trial court to decide that whether this was in fact the intention of the patent holder to limit it, or whether they did it for some other reason. That has to be looked into, and on the basis of that the doctrine of equivalence has to be studied. And this is the end of this class, and in the coming class I will be discussing about what you I will be discussing about the Indian understanding of doctrine of equivalence. In India also we do have an understanding of equivalence, and that is known as Peat and Marrow doctrine, and then we will also try to understand that what are the rules of claim construction which are applied in India and as well as in other countries. Thank you so much.